Mr. Mbikiwa. Good morning, everybody.
Good morning, Chair.
Are we ready?
We are indeed, Chair.
Mr. Y, are you ready?
I am, Chair.
Thank you very much. The oath you took continues to apply. You understand?
Yes, Chair. Understood.
Okay, thank you. Let's proceed.
Mr. Y, we concluded yesterday with you dealing with the high-level review panel report, which made various findings regarding the diversion of the Special Operations Unit and its mandate. And I think we left off on your evidence to the effect that Ms. Mieni did not qualify for the security protection that this unit was providing to her.
Correct.
I would like to begin this morning and to conclude your evidence by focusing on the services that were in fact provided to Ms. Mieni. And for that purpose, I would like to take you to the affidavit of Mr. Munsami. If you can turn to page 15 of the bundle in front of you, that's DD 23.
Okay, Chair.
Chair, as always, this affidavit is included in the bundle on a provisional basis, on the basis that it doesn't, as far as we are aware, raise contentious matter. But it's provisional and subject to your direction in due course.
Is it an annexure to Mr. Y's affidavit?
No, Chair. It's an additional document to Mr. Y's affidavit.
Because if it's not an annexure to Mr. Y's affidavit, then it should have been given a different, separate exhibit number.
We can certainly arrange for that, Chair.
Because what exhibit DD 23 was said to be was Mr. Y's affidavit and annexures to it.
Indeed, Chair.
And if it's not an annexure, it means it has not been admitted and it has not been given an exhibit number.
Indeed, Chair. Chair, can I then request that Mr. Munsami's affidavit and its annexures be included as DD 23B?
We can do that. You'll then have to remember to, it means the, or otherwise we can put it on a separate small file as DD 2024.
DD 23B, Chair.
Well, if we, yeah, we could.
There's already a DD 24, I understand, Chair.
If we keep it inside this lever arch file, we can have Mr. Y's affidavit and in its annexures as 23A, and then this affidavit and its annexures as 23B.
Indeed, Chair.
And then the lever arch file must make it clear it contains those two exhibits. That's one way of doing it. Another way of doing it is to take Mr. Munsami's affidavit and its annexures out of this and have it in a separate small file. Then it can have its own exhibit, or it might still be D23B, but then this one will have to be A, but kept separate.
Chair, I think given that we will be referring to Mr. Munsami's affidavit during the course of Mr. Y's evidence, I think your first proposal would make sense, that we keep them in the same file but divide them into 23A and 23B and label the file accordingly to reflect that.
Yes. What is the last page of the annexures that belong to Mr. Munsami's one?
It's page 273, Chair.
Is that the end of the file?
I apologize, Chair. It's 167 is the end of
the annexures to Mr. Munsami's
the
one.
annexures to Mr. Munsami's affidavit.
167.
Indeed.
And then what comes after 167 is the high-level panel report
Indeed, Chair.
up to the end.
Up to the end.
Is it an annexure to Mr. Wise's affidavit, or is it separate?
It's a separate document, Chair. It was added afterwards.
Yeah, you see, then...
He refers to it
then-
in his affidavit, Chair, but it wasn't attached.
Yes, then what should be done then it is that the high-level report should be a separate exhibit. It will need to be C, 23C. Well, in that event, what we might not need to change anything. It seems to me that there is no annexure to Mr. Wise affidavit.
Indeed, Chair.
So you people allowed me to say Mr. Wise affidavit and its annexures, but there are no annexures.
Chair, I can't allow us people to take the blame. It was mine entirely.
We'll need to correct that now. We'll need to correct
Security Services at South African Airways, Kempton Park, Johannesburg. Can I ask you to turn over to page 16?
Yes.
And we pick it up from paragraph 7. I won't read the entirety of this into the record, but I'll duties was to provide Ms. Mieni with the services of a close protection officer, which he did together with 3 other members of South African Airways Security Services for about 4 months. He then, in paragraph 9, says that he, after this 4-month period, Ms. Mieni obtained a new security detail, but that he did not know who appointed them or where they came from. And that's despite him being the head of Group Security Services. At paragraph 10, he says that Ms. Mieni breached SAA policy by not making prior arrangements before arriving at SAA with her own security detail. And then at paragraph 11, which is on page 18, he says that the people with her would refuse to sign in, which he says was also in violation of South African Airways policy. Do you have any knowledge of any of this?
I don't, Chairperson.
And do you have any reason to doubt this version?
I don't, Chairperson.
And if these agents or members who were protecting Ms. Mieni had been legitimately deployed to South African Airways. Do you know of any reason that they might not want to sign in?
There should be no legitimate reason, Chairperson. They would have to follow the existing policies and procedures.
Thank you. Then at paragraph 12, Mr. Munsami says that he didn't confront Ms. Mieni about this, but he took note of incidents and recorded them. And he refers to CCTV footage of the individuals who used to accompany Ms. Mieni at SAA as her security detail. He attaches a photograph from that footage, which I'd like to take you to. That's at page 160. And I ask you to turn there.
Okay, I'm there, Chairperson.
Have you been shown this photograph before?
Yes, I have, by the investigators from the Commission.
And are you able to identify any of the people in the photograph?
Chairperson, the bottom left-hand corner, the individual we identified as a member of the State Security Agency.
And are you able to indicate who he is?
Yes, Mr. Zama Mtolo. He was a member of the Special Operations Unit.
And do you know anything about why he would have been deployed to South African Airways?
No, Chairperson. As I indicated yesterday, we have found no paperwork, files, requests, deployment plans, project plans that would indicate that this was an official undertaking.
Thank you. The other aspect of Mr. Munsami's affidavit I'd like to refer you to is an incident report that he talks about in his affidavit. If I can ask you to turn back to his affidavit at page 19.
Okay, I'm there, Chairperson.
At paragraph 15, he refers to a report about an incident with Mr. Wolf Meyer, who was the Chief Financial Officer of SAA until the end of 2015. He attaches a copy of the report, which I'll take you to in a moment, and he says that the report indicates that, it says my Mieni, I assume that should be Miss Mieni, instructed the security personnel accompanying her at a meeting with Mr. Meyer to confiscate a recording pen from him. Can I ask, is it within the mandate of SAA members to confiscate electronic equipment?
You mean SSA? You said SAA.
Apologies, Chair. SSA members.
Yeah, thank you for that, Chair. No, it wouldn't be within the mandate. We don't have executive powers. And it would be the responsibility of the SAA security personnel to implement and police whatever their rules and regulations are.
Indeed. And you'll see that at paragraph 16, Mr. Munsami says that it is not the mandate or policy for group security services, that's group security services at SAA, to confiscate any belongings of EXCO or board members in execution of their duties.
I see that, Chairperson.
I skipped over a part of paragraph 15, if I can just refer you to that as well. He says he was informed by his predecessor, Mr. Johan de Waal, and was told by Mr. Nico Bezuidenhout and Mr. Wolfmeyer that the security personnel who used to accompany Ms. Mieni at SAA would confiscate laptops and phones from people before they went into meetings with Ms. Mieni on her instruction. Can I take you to the report which refers to an incident of that kind? You'll find that on page 161. And before I read the report into the record, if I could ask you to turn to page 162 and just read who it says it's compiled by.
It says it's compiled by Zaza Ngema.
Do you know who Zaza Ngema is?
I don't, Chairperson. As mentioned to the investigators, in compiling the list of agents, one might have indications of someone with the nickname of Zaza, but we are unable to say that it would be Zaza Ngema. Therefore, we couldn't confirm categorically to the Commission that it's the same person.
Okay, but in the list that you've compiled, you say there's a Zaza.
Correct, Chairperson.
If we turn back to page 161, which is the report,
I'm there.
and we go to the background section, it says, on the 3rd of July 2015 at 7:45, I, that's the compiler, Zaza Ngema, received an urgent call from Mpendulo requesting me to assist him in transporting Ms. Mieni from OR Tambo International Airport to the SAA Business Park for a board meeting. Do you know who Mpendulo is?
I don't, Chairperson.
The objective is described as to ensure that Ms. Mieni is safely transported to her board meeting at SAA Business Park and that her safety guaranteed. I then want to go to operational support. It says there Zama was called in to back me up for any eventuality and utilize his car to transport Ms. Mieni. He arrived at the hotel around 11:40. Do you know who Zama is?
Chairperson, I assume it's the individual identified in the CCTV footage, which would be Zama Mtolo.
He arrived at the hotel around 11:40. Ms. Mieni and I briefed him of the anticipated situation at the SAA Business Park board meeting. Zama and I came up with an operational plan. The operational plan says we agreed that we will drive in Zama's car to the SAA Business Park. All board members are to surrender any electronic devices that they may have, access to the boardroom to be monitored by Zaza, and alternate with Zama. Mr. Y, can I then ask you to read the report into the record?
Okay, Chairperson. Starts at 12:15. We left the hotel with Ms. Mieni and proceeded to her board meeting at the SSA Business Park. Upon arrival at the entrance at 12:30, the security guard denied us access since Ms. Mieni didn't have her access card. Ms. Mieni had to call the owner of the security company for us to be granted access to the premises. We were granted...
Hang on, Mr. Mpikiwe. Why do you need him to read the report? He wasn't there, I assume.
He wasn't, Chair.
Yes.
He wasn't. The report relates to an incident that has been referred to, I understand, previously in the evidence of Ms. Stimple.
Mm-hmm.
An incident involving the confiscation of a recording pen.
Yes.
The purpose was simply to read the report into the record. It's an attachment to Mr. Munsami's affidavit.
Yes. No, I think if you want him to confirm anything, whether it's the kind of thing that people in the State Security Agency
Yes.
do, you can just tell him what the report says in regard to that issue, and then he can say whether that's the kind of thing that they do. But otherwise, there is no need for him to read a report
Certainly, Chair.
that he knows nothing about.
Certainly, Chair.
Yeah, okay.
Mr. Y, at this, what this report indicates is that Ms. Mieni had a board meeting at which no one was allowed to have cell phones, and thereafter had a meeting with the CFO at which she left the meeting, took the recording pen and handed it to the SSA agents and instructed them to confiscate it. In your experience, is that what members of the SSA are empowered to do?
No, Chairperson. I might add that within the SSA, we have our own security protocols in which one would lock up your cell phone in a cell phone box, and you know that you're not allowed recording equipment. But at external meetings, we may have advised the SSA security head that this is the best practice. but we don't have the executive power to actually go and confiscate any equipment off any of the board members.
Thank you. Chair, that concludes Mr. Y's evidence, insofar as my questioning is concerned.
Yes, okay, no, that's fine. Thank you very much, Mr. Y, for coming to give the evidence. We appreciate it very much. Should we need you to come back, we will ask you to come back, but thank you very much, and you are excused.
Thank you, Chairperson.
Thank you.
Chairperson, could we stand down for a few minutes simply to rearrange logistics for the following witness?
Okay, how much time do you need?
5 minutes, I think.
5 minutes.
Yeah.
We'll adjourn for 5 minutes. We adjourn.
All rise.
Ms. Hofmeyer.
Morning, Chair.
Morning.
Chair, Mr. Mbikiwe will be presenting the evidence of our next witness, but I request an opportunity simply to do a short opening before this next session of evidence, because
Yes.
I indicated at the start of the aviation session that in respect of each new investigation area, I propose to do a short summary of what would follow. Chair, this is the last installment of this phase of evidence that we will be presenting, and we again shift our focus. Today and tomorrow, we propose to deal with the role of auditors at state-owned enterprises. Chair, auditors have been described by our courts as the watchdogs of institutions that they audit. That actually comes from a case involving PricewaterhouseCoopers previously, and we're going to have a witness from PwC testify tomorrow. That was Thoroughbred Breeders versus Pricewaterhouse, 1999, 4SA 968, a decision of the Witwatersrand Local Division as it was then. Chair, it is an important incident of the responsibility that auditors bear when they audit companies, to both be independent as a matter of fact, but also to be seen to be independent. In colloquial audit speak, that is referred to as having independence of mind and independence of appearance, and both are essential to the proper discharge of their functions. Chair, there have been calls for this commission within its investigations to look at the role that auditors have played within the public sector in particular. And the calls originate from an appreciation that they play a role of watchdog. And if there are acts of state capture, corruption, and fraud taking place in those institutions, the legitimate question that may be asked is, well, what role did auditors play and what responsibilities may they have had to identify what was going on? And it's for that reason, Chair, that we propose over the next 2 days to investigate this role insofar as it related to the SAA group of companies. Chair, the evidence that we'll present in the next 2 days will explain that state-owned entities are by default, in terms of the law, to be audited by the Auditor-General. However, where there are occasions where an external audit firm can be appointed to audit a state-owned enterprise, where that happens, it requires the concurrence of the Auditor-General. And I think it would be fair to say, but Mr. Sokombela, who is our witness soon, will be the expert on this. It may be fair to say that when external audit firms play this role, they stand in the shoes or the place of the Auditor-General, who would otherwise, by law, be doing the audit as a matter of default. Chair, as a consequence of their role in state-owned enterprises, auditors have additional responsibilities to those which they bear when they audit private companies. And those additional responsibilities include, amongst other things, an obligation to assess whether state-owned enterprises have complied with their PFMA obligations, insofar as that may have an impact on the audit that they conduct. And so we propose to explore in the next 2 days the role that PwC and Nkonki Incorporated played when they were doing the joint audit of SAA for the financial years between 2012 and 2016. And the question that will be posed is whether in the course of that audit work they properly discharged their obligations. We will ask that question because after they'd completed their 5 years of audit work and had given SAA clean audits each year from 2012 to 2016, the Auditor-General stepped in and took over the audit in 2017 and found the finances of SAA and its group in a state that can only be described as shambolic. Chair, we will present the evidence of 2 witnesses. The first will be Mr. Polani Sokombela, who is a business executive in the Office of the Auditor-General. And after that, we will be presenting the evidence of Mr. Pule Motibe, who was the audit partner from PwC, who was assigned to the SAA audit for the years 2014 to 2016. Chair, we propose to explore the following in their evidence. Mr. Sokombela will provide a background for how audits of SOEs are supposed to be conducted with reference to the relevant legislation and the applicable auditing standards. He will also enlighten the Commission on what the Auditor-General found when it moved into SAA to conduct the audit for the 2017 financial year. And after Mr. Sokombela, we will present the evidence of Mr. Motibe of PwC, and we will explore the following questions with Mr. Motibe. First, we will traverse with him the fact that, except for the first year of PwC and Nkonki's appointment as auditors of SAA, in all 4 subsequent years, they were appointed without any procurement process having been followed. This occurred at a time against the advice of the Bid Adjudication Committee of SAA and at a time when a legal opinion had been obtained indicating that a failure to follow a procurement process before appointing auditors would be unlawful. Their own appointment, on the basis of those facts, therefore constituted irregular expenditure for 4 solid years, but it was never disclosed as such in the financial statements of the SAA group. We will then explore why it was that PwC and Nkonki both had joint business relationships and made payments to another auditing firm known as Kwinana and Associates during their audit work for SAA. Now, Chair, Kwinana and Associates was the auditing firm of Ms. Yake Kwinana, who was one of the non-executive board members at SAA during the period that PwC and Nkonki were appointed as auditors, and she was also the chair of the Audit and Risk Committee of SAA. And in that role, she would approve the audit fees to be paid to the auditors in each successive year. We will explore why not one of the significant transactions that have been dealt with previously in the evidence before this Commission, and which there are indications may have involved fraud, corruption, and elements of state capture, were not identified by the auditors in that period as a possible reportable irregularity. And finally, we will probe how it could be that PwC and Nkonki gave clean audits to SAA for those 5 years when they audited the group, only then to reach a situation where the Auditor-General moved in and in 2017 found a situation that was so dire that a qualified audit had to be given and a restatement of the previous years of account. Chair, that is just an introduction to what we propose to deal with in the next 2 days. With your leave, I'd like to hand over to Mr. Mbikiwe.
Thank you very much for that introduction, Ms. Hofmeyr. Mr. Mbikiwe.
Thank you, Chair. Chair, I intend to proceed straight into the evidence of Mr. Sokombela, so I would ask if he could please be sworn in.
Please administer the oath or affirmation.
Please state your full names for the record.
Polani Sokombela.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you will give will be the truth, the whole truth, and nothing else but the truth? If
Yes.
so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may proceed.
Thank you, Chair. Chair, to start with, can I ask that Mr. Sokombela's affidavit and its annexures be admitted as DD 20A to DD 20D?
Mr. Polani Sokombela's affidavit will be marked Annexure or Exhibit DD 20A. Now, you have got BC
And D, Chair.
up to D, but those are annexures to the affidavit. They are not separate
Indeed.
affidavits.
Indeed, Chair.
It might be confusing to do them like that. Maybe because they are in different live arch files, maybe how have we done this before?
Chair, my understanding is that we've done it in this way, where the affidavit and annexures have gone over a file, the next file has become the same number but A, B, C, D, etc.
I'm sure we have done it like that, but for some reason this morning, something seems wrong about doing it that way.
Chair, I'm not sure that
You see, when you say DD20A, that at least this morning, I don't know about other days in the past, this morning, that seems like an exhibit on its own. When you say exhibit DD20B, that sounds like an exhibit, a separate exhibit on its own, C, D, and so on. Whereas the idea is that it's one exhibit with annexures. I don't know how I'm thinking this morning.
Chair, I'm not sure what to suggest because it will, of course, be necessary to refer to the different files in the course of...
Yes, let's hear Ms. Hofmeyer, who has led quite a lot of, might be able to tell me that there's something wrong with me this morning.
Not at all, Chair. Chair, can I say we have previously, where we have had annexures that extend beyond one file. In order for us to be able to navigate which file you need to have in front of you or the witness needs to, we have allocated a B, C, and D. So that we have certainly done previously.
Yes, and it has worked well.
It has, because only to assist us in identifying which file to place in front of us.
Yes.
It has occurred to me, though, that one way we may do it is, for the purposes of entering it into the record, we could enter it as Exhibit 20, which will run with an affidavit and annexures commencing page 1, and then we give the indication of the last page. So that would be how it's entered into the record. For convenience here, we could pull out B, C, and D just so that we know which file should be in front of us.
Yes.
But I actually don't know if that will complicate things more.
Well, one would like to depart from how we have done
We've
it in the
entered
past
it.
unless
Indeed.
really there is a problem.
Yes.
Your feeling is that maybe we could stick to how we have done it in the
I
past?
think so, just provided
Yes.
when we enter it into the
On those issues where your experience and expertise can assist in shedding light. Can you begin by telling us what your qualifications are?
Thank you, Chair. My qualifications, I'm a qualified chartered accountant.
And your tertiary education?
My tertiary education, I've got a BCom degree. And then I've got honors in accountancy, or they call it the certificate in the theory of accounting. And then I wrote then my board exams with SICA, and then I wrote then my public practice examinations with the Independent Regulatory Board for IRBA, for auditors. I'm sorry.
Thank you. And what is your position?
Chair, my current position, I'm the business executive in the Auditor-General of South Africa.
And what positions have you held previously in the Auditor-General?
Chair, the positions that I've had previously in the Auditor-General, I actually started my career at the Auditor-General as a trainee accountant. And after finishing my articles and also finalizing my qualification exams, then I was promoted to be an assistant manager. And as I was gaining experience, then Chair, then I became a manager and a senior manager, and then now that I'm a business executive.
How many years have you been at the Auditor-General?
Chair, I've been with the Auditor-General, this is the 14th year.
Thank you. And can you tell us what your involvement was in the South African Airways audit?
Chair, my involvement in the audit of South African Airways, initially it started when the South African Airways was moved from the Department of Public Enterprises to National Treasury. I think it was somewhere around 2015, if I'm not mistaken. I think there were challenges as far as SAA is concerned, and at the time, then SAA was moved. The business unit within the Auditor-General that I'm currently a business executive for is responsible for, among others, the audit of National Treasury. And at the time, I was a senior manager, also overseeing the portfolio at the time. And then I became involved then as when SAA was not audited by us, but was still audited by the private sector firms, i.e. PwC as well as Nkonke. And Chair, after then the Auditor-General then was appointed for the 2016-17 financial year, then I became involved as the senior manager responsible, or the engagement manager, what do you call, for the audit of South African Airways, as the person then that is responsible and also accountable in terms of delivering the audit report of SAE. So that was my involvement, Chairperson.
Thank you. If we pick it up at your affidavit on page 4, you deal there with the mandate of the Auditor-General. Can you tell us what that mandate is?
Chair, I would like to
I apologize. I should have said at the outset, we will be beginning in your file marked DD20A, which contains your affidavit. When I refer you to page numbers, I'm referring you to the numbers in red on the top right-hand corner. And we're at page 4, and you deal from paragraph 6 with the mandate of...
Well, if he didn't have his file in front of him, it seems to me that we might not have asked him to confirm.
Indeed.
Yeah, so you might have to do
Indeed.
that first, yeah.
Mr. Sokombela, can I ask you to turn back to page 1? And can you confirm that that is the affidavit you provided to the Commission?
I confirm, Chair.
And if you turn to page 42, is that your signature under where it says deponent?
Yes, Chair, that is my signature.
And do you confirm that the contents of the affidavit are true and correct?
I confirm, Chair.
Thank you. You were about to tell us about the AG's mandate.
And that's on page 4.
That's on page 4.
Thank you, Chair. Chair, the Auditor-General of South Africa is a supreme audit institution of the Republic of South Africa. Its mandate stems from Chapter 9 of the Constitution of the Republic of 1996, herein referred to as the Constitution, which means that it exists to support the constitutional democracy. The Auditor-General is independent, subject only to the Constitution and the law, and must be impartial and exercise its function without fear, favor, or prejudice. The Auditor-General accounts to the National Assembly by tabling its annual report in Parliament.
Can I ask you, Mr. Sokombela, is the Auditor-General required to audit an entity such as SAA?
Chair, the Auditor-General is, in terms of the Public Audit Act, there is a section there that is called, that is Section 4.3. And, Chair, the Section 4.3 then is the section...
4.3 would be Section 4, subsection 3.
Yes, Chair.
Okay.
Subsection 3. In terms of Section 4, subsection 3 of the Public Audit Act, the Auditor-General is empowered to audit South African Airways. Yeah, so that is the answer, Chair.
You say it's empowered. My question is whether it is required.
Required in this case means obliged.
Chair, the Auditor-General is not obliged. The Auditor-General can make a discretion, has got a discretion whether he can audit South African Airways or whether he can opt out.
Thank you. And what are the kinds of factors that the Auditor-General would consider in deciding whether to audit an entity itself or to opt out?
Chair, there are many factors that the Auditor-General would consider. I think one of the key factors, for an example, is the capacity, is whether the Auditor-General has got the capacity and the technical expertise to audit that particular entity or not. And one of the most important thing then is to ensure then that we've got the right people. They are the right people that will audit, because some of these state-owned entities can be very complex and very technical.
Okay, so capacity is one issue. Are there any others that the Auditor-General would consider before deciding whether to take on the task of auditing a particular entity?
Yes, Chair. I think one of the key one is skills and capacity, and also there may be other factors that the Auditor-General may deem appropriate, depending on him.
So, so when you say skills and capacity, you look at the two as separate factors. Is that right?
Yes, Chair.
Yes. And as far as capacity is concerned, when you use capacity in this context, you mean enough people.
Yes, Chair.
To do the job.
Yes, Chair.
And when you refer to the skills, you're referring to people who may have particular skills that are required in a particular entity.
Yes, Chair.
Okay.
Thank you. Before we talk about the role and the duties that auditors, both private auditors and the AG, bear, I'd like to ask you about something that isn't addressed in your affidavit, which is about because we're talking here about state-owned entities. What are state-owned entities required to do internally from an audit perspective?
Okay. Maybe you may need to clarify further, Chair, in terms of when you're saying internally, what does that mean?
Yes.
I'm talking about the internal audit function of state-owned entities.
Thank you very much, Chair. Chair, in terms of the Public Finance Management Act, And one of the governance requirements is that the state-owned entity is supposed to have an internal audit function that is fully capacitated with skilled people, and also that reports to the audit committee functionally. Yes, so that is the requirements, Chairperson.
And because it's something we're going to come to later, what is meant by the term internal controls?
Chair, the word internal controls, in simple terms, if I may simplify it, Chair, is basically the controls to actually ensure then that the financial administration of the entity is at the right level, i.e., you've got policies and procedures, you've got the standard operating procedures internally to ensure then that when transactions are done, they are done in a manner that will not, will not actually cause wastage or will not cause fraud. I think an example that I can give is that, for an example, if you are purchasing the bottle of water in an entity, the person that orders, that places an order, and the person that approves the transaction, and the person that pays, ideally, for the internal controls to be at least to be believable, needs to be separate people. For example, you need to have segregation of duties, because if it's one person that will buy that bottle, there's a risk that the person may not actually buy a bottle, might buy something else, or maybe the money might go somewhere else. So that might be my simple explanation.
So it's basically measures, internal measures taken by the entity to ensure that from a financial point of view, things are done properly.
Absolutely, Chairperson.
Thank you. I'd like now to move to the role of external auditors. You deal with that on page 6 of your affidavit. I refer you to your affidavit simply to orientate you. Can you tell us what the role is that external auditors play for state-owned entities, and elaborate on the importance of that role?
Chairperson, the role of external auditors in the context of state-owned entities is to provide the independent assurance to the users of the annual report or the financial statements of that state-owned entities. The users include those that are charged with governance, and actually ensure them that we also provide assurance on performance information. We also provide assurance also on applicable laws and regulations to ensure then that there is compliance with those laws and regulations.
When reference is made to external auditors in this context, we know the AG is external to all the entities, but is it included when you use external auditors in this case, in this context, or external auditors is meant to refer in this context to private auditors?
Chairperson, it's even the private sector auditors, in the context that I've explained, in terms of what their roles are, is the same.
No, I accept that you are referring to them. What I'm not sure about is whether you are also including the Auditor-General, or whether what you have just said doesn't apply necessarily to the Auditor-General. You are referring to or focusing on the private firms, or whether that's meant to include the Auditor-General as well.
That include the Auditor-General, Chair.
Oh, okay.
Thank you. Certainly, Chair, in the legislation, when it refers to private firms, it uses the word private.
Okay.
Yeah. Mr. Sokombela, I'd like to pick up on something you say on page 7 at paragraph 15 of your affidavit. You say there that an audit does not provide absolute assurance. Can you explain what you mean by that?
Chair, the audit the reason why we're saying the audit does not provide an absolute assurance is the fact that there are many factors. For an example, the audit evidence on itself is, you may find out that we are not always at the auditee or at the client at times. The people that are always at the client is management, or those people that are charged with managing the entity. So, and even how we plan and approach our audits, we don't test everything, Chairperson. We normally select a sample because at times it can be impracticable for us as auditors to come and test for everything. So there is that chance that there may be something that the auditors will leave. So even in our wording, we are very careful in terms of how we actually put it. That's why then it becomes our own audit opinion. And we like using words like in our judgment. It is our judgment, to actually ensure then that, we're not saying just rely 100% in terms of what we do.
You mentioned that you don't look at everything within a business and you look at samples. How do you determine a sample?
Chair, how do you determine a sample?
I'm not sure whether you seek to say how they select the samples.
Indeed, Chair.
Yeah.
Thank you. I'm
how
grateful.
do you decide on what samples to look at?
Thank you, Chair. Chair, we've got, I think, the auditing standards, because the sampling is a scientifically tested method, where in a set of population, an auditor, based on the understanding of the population itself. For an example, let me make an example on, let's say I'm testing whether the revenue that the entity is reporting, I'm testing whether then the revenue is really valid revenue. Then what then we normally do is that then, based on the understanding of that entity, then we've got tools then that we have, where then they will determine in terms of then how then do I select then the sample size. For an example, other firms will have their own methodologies. For example, in the Auditor-General, the minimum sample, for example, that you test is 30 items. And then depending then on the magnitude or the size of that particular population, it can go up, because the most important thing is to ensure then that you get sufficient appropriate audit evidence. So it's scientifically tested, it's a scientifically tested method. So that is basically, it's as simple as that, as like that, to say, if there's a population for revenue, for an example, then I will then, based on the audit methodology, then determine whether then how much sample should it be selected, and that is based on the audit methodology, basically.
You talk about population of revenue. Please explain that. Some of us need to be educated on auditors.
Thank you, Chair. I apologize.
Yes. No.
Yes.
You use language that you are used to use.
Yes, Chair. Chair, when I'm talking about the population, for an example, if I'm selling fat cooks for R2 each, you will find out then that in a day, then 20 fat cooks will be sold. Then I will record then in my books that for each transaction I've received R2, and those transactions will be 20 transactions. Then those 20 transactions, then it becomes a population.
Okay, all right, thank you. Thank you.
Mr. Sokombela, another thing you say at paragraph 15 is that external auditors do not audit to identify and report on fraud and corruption. But the audit processes could identify possible fraud and corruption which should be reported to management. Can you explain what you mean by that?
Chair, the objectives of the audit process is to express fair presentation of the financial statements, and also to identify if there are any material findings in compliance with legislation, and also to identify whether there are any also significant findings on performance information or the key performance indicators in the annual report. So that is basically solely then the objectives of the audit process. However, as it explained here on paragraph 15, in the quest then of testing and of auditing, we may come across on issues of corruption. And then when we come across then with those issues of corruption, then we report them to those charged with governance for further investigation.
Well, I wanted to ask you earlier, let me ask you now. The tools you use to select the samples that you are going to look at, how much room do they leave for an auditor to miss something quite critical that later on people might look at and say, but how could he have missed it? How much room do those tools that you use leave for that kind of thing? Or should one understand that those tools enable you to select samples that will lead you to something that's critical? If really there is something critical you have missed, the fault is not with the tools, it's with you.
Thank you very much, Chairperson. That is a very good one. Chair, before we go and decide which sample to select, I think the step that perhaps maybe I should have talked about is the duty of the auditors to perform rigorous risk assessment processes. Because it's important, and it's for the auditors to actually ensure then that they obtain an understanding of the entity and its environment. And to also, in the process, also be able then to project in terms of which transactions or which issues might pose a risk in the audit process. So, Chairperson, that process then gives you then an opportunity then to say, when I'm going then to select my sample, if then I've identified that there are issues of risk that I've already identified in my risk assessment processes, I will also go and identify those issues and put them separately. And then I will test those ones specifically. We'll call that a specific selection. We're not using a sample then. You know, Chairperson, we use a sample then when you are not on the remaining population, to say, oh, there's a remaining, this is the remainder.
Okay.
But let's just test then this remainder.
Yes, okay.
Yeah, but it's incumbent then to us as auditors to ensure then that we perform those risk assessments to identify where the problems might be.
Okay.
Yes.
Okay. Now, excuse me, would the rigorous exercise that you talked about that an auditor would need to do before going into an entity, would that include, in the case of an SOE, for example, checking news about the entity in the public domain? What's been said about it? If, for example, There have been articles about corruption, about a certain contract, certain tenders that's been in the news, and then collect those and put them together and then say, when I go in, I want to find out about this. Would that include something like that?
Absolutely, Chairperson. It includes something like that.
Okay, thank you.
Thank you, Chair. Chair, I see it's 11:15. It might be an appropriate time for the break.
Okay, we'll take the short adjournment and we'll resume at 11:30. We adjourn.
All right.
Okay, let's continue.
Thank you, Chair. Chair, I can confirm that over the break, our bundling team has attended to the proper arrangement of those
Yes,
files.
okay, thank you.
Thank you. Mr. Sokombela, just before the adjournment, we were talking about external auditors identifying fraud and corruption, and you indicated that while that's not the objective, they can do so in the course of an audit. Can you help me with a few concepts? Can you tell me what irregular expenditure is?
Chair, irregular expenditure is an expenditure where it has been incurred. However, in the course of it being incurred, there was non-compliance with the legislation. In most instances, the PFMA.
Thank you.
And irregularity in the context of an irregular expenditure is not confined to a process, to a legal process. Is that right? Or is it confined to a process?
Chair, it is confined to a process. Chair, if I may, Chair, just to make an example. A simple example will be that the PFMA might say, when you're purchasing goods and services, you need to obtain 3 quotations. But if an official of an entity then didn't go and obtain 3 quotations, then but then only sourced 1 quotation, then that expenditure then will become irregular because the official ought to have invited 3 quotations.
So you are saying it doesn't speak, irregular expenditure doesn't speak to whether the funds were used for the purpose for which they were supposed to be used. In other words, if I take 10,000 rand of the entity and use it to buy a computer, but I followed the right process in terms of tenders or whatever, but I'm using it to buy a computer when it was meant to be used to do something else, that would not fall under irregular expenditure, it would fall under something else? Or would it, because that's not the process, that's using it for a wrong purpose, or is it regarded as process?
Chair, in the example that you gave, if the monies were intended for something else but were utilized for something else, if the due process was followed, i.e. those that have initially approved that this money is for something else, but when then the change was made, there was due process in terms of then there were approvals that were made, and there was no non-compliance that was identified, that may not be irregular expenditure. However, if these monies were intended for something else but were utilized for something else and there was no approval for that, it may become irregular expenditure.
But what if what if nobody is supposed to approve that this money be used for something else? And nobody has approved that it be used for something else, but it has been used for something else. Would it fall under irregular expenditure, or would it fall under something else?
If there is no legislation, Chairperson, that regulates the utilization of that money, it may not be irregular expenditure, it may be something else.
And is there a particular heading under which it would fall, as far as you know, or not necessarily in terms of a jobs auditor? If I use money, I use money for something that it should not be used for. I use it to buy my, well, maybe I shouldn't make an example that might give a confuse further. So in other words, if what the money is used for is not the lawful purpose for it, I don't know whether I should say authorized purpose. The normal, there's no normal label that it would fall under, or the normal label would be irregular expenditure.
Chair, it depending. For an example, if the money is not utilized for the benefit of the entity itself, it may become then classified as fruitless and wasteful, which is another concept.
Yes. So, but that concept looks at whether the purpose for which the money was used added any value to the entity. Is that right?
Yes, Chairperson.
Yes. Okay. Thank you.
Thank you. I was indeed about to go to fruitless and wasteful expenditure, so that's helpful. Mr. Sokombela, would you agree that then that while irregular expenditure and fruitless and wasteful expenditure is not always because of fraud and corruption, they can be indicators that fraud and corruption has taken place in an entity?
Yes, Chair, I agree. Hence, in our approach, once we identify irregular expenditure, we always recommend to management and those charged with governance to investigate.
Yes.
Would it be a correct understanding of these two concepts, irregular expenditure and fruitless and wasteful expenditure, to say the fruitless and wasteful expenditure is more serious than irregular expenditure, generally speaking?
Chair, the fruitless and wasteful expenditure is where it's confirmed that there was no value added to the entity. However, on the irregular expenditure as well, an investigation might reveal that in actual fact there was no value that has been added.
But what I want to establish is that on the face of it, when somebody says a certain entity or government department had irregular expenditure amounting to 50 million, the picture that the citizenry should have in mind should not necessarily be that money was wasted, because the process might have been not right, but whatever was done might have added value and may have needed to be done. It's just that it was not, the right process wasn't followed. Whereas with fruitless and expenditure, fruitless and wasteful expenditure, I would imagine that the citizenry should say, so these people have wasted our money. So in other words, without going further, once the Auditor-General says it's fruitless and wasteful expenditure, aren't we entitled to say these people have wasted taxpayers' money? Whereas with irregular expenditure, it might simply mean that, not that they wasted money, but that they didn't follow correct processes. But sometimes in not following correct processes, there might be corruption and so on. But sometimes there might be no corruption. It might just be a failure to follow processes. Is my understanding right?
Yes, Chairperson, you've actually unpacked it very well.
Yes, okay, thank you.
Thank you. The final concept I'd like to ask you about is a reportable irregularity. What do you understand a reportable irregularity to be?
Chair, the reportable irregularity is a concept in the Auditing Professions Act, where there may be certain transactions that may lend themselves to plausible or in-comfort explanations, where there may be non-compliance that has been committed by a person responsible for the management of the entity itself. And the duties then of the auditor then in that instance is to immediately write to the Independent Regulatory Board for Auditors and the details of that reportable irregularity. And also then the auditor then is also required within 3 days of identifying that irregularity and reporting it to the Independent Regulatory Board to also then report to management and those charged with governance. And also should give them an opportunity to explain whether then this really is a reportable irregularity. And I think one concept that I forgot here to explain, Chair, is that for it to be a reportable irregularity, there should be a material financial loss that has been incurred by the entity. There should also be, a breach of fiduciary duties by those that are charged with governance in the entity. And in my explanation, Chair, I said then the auditor should provide then an opportunity then to those charged with governance one is to actually just to give comfort to the auditor, whether the auditor was correct to say this is a reportable irregularity, and submit information to the auditor. And based then on that information, then the law then, I think it's actually Section 45 of the Auditing Professions Act. It requires then, within 30 days, the auditor to report back to the Independent Regulatory Board. Is either then, when they're reporting back, they need to specify whether, in their opinion, that no, in actual fact, there is no reportable irregularity. And that would be in a case where maybe the auditor is satisfied with the explanation of the entity. Or also the other important thing is that it may be taking place or it may be continuing. Then IRBA, the Independent Regulatory Board for Auditors, then can continue then with their own processes to deal with it.
So if you could just repeat for me what the essential features of a reportable irregularities are, if you are able to. In other words, how does somebody see that this is a reportable irregularity?
Chair, for it to be a reportable irregularity, there should be non-compliance, or there should be fraud, or there should be theft. And also this should have resulted in a material financial loss to the entity, or suspected. It can also be a suspected material financial loss. And also, I think what is also important is that this loss should be to the entity itself, or it can be to the shareholder, or it can be to the employees, or to other stakeholders of the entity itself. So those are the critical features.
Essential features.
And also, I think one other key issue is that it should be committed by somebody that is in management or maybe in the board of directors.
Okay.
So I think those are the essential features.
Okay. And the theft and fraud, at that level, they should be, it's fine if they are suspected, and not necessarily, the person shouldn't necessarily be sure that they have been committed, or should they be sure that, as far as they are concerned, there has been theft and there's been fraud, or if they suspect, that's enough?
Chair, you're quite right. If they suspect, as long as there are indicators, Chairperson, that something might be happening here.
Yes, okay, thank you.
Thank you, Chair. Can I ask, what are the sorts of documentation that you're looking at in order to identify irregular expenditure and fruitless and wasteful expenditure? The Chair asked before the break about external documents in the media, and you confirmed that that is something to which you would pay attention. What about things within the entity?
Chair, I think the key issue, maybe I must just explain in terms of how we got to, maybe how do we get into the issue of identifying maybe the irregular expenditure itself. I think I've mentioned, I think in the opening remarks, the issue of the risk assessment process. And if you remember, Chair, is when then you asked if maybe we do consider the media and stuff. But the most important thing that when we're doing that risk assessment process is to document the business process. And when we're documenting that business process is to ensure then that the processes of the entity also are aligned to legislation. One of the most critical things that we look at is the supply chain management policy of the entity. Because the supply chain management policy of the entity needs to comply with Section 51 of the Public Finance Management Act, which Section 51 also is derived from Section 217 of the Constitution, where the procurement process should be fair, equitable, transparent, and competitive. So we do then that business process. We're looking at the supply chain management policy. We also, in the process, look at allegations of fraud that has been made. What are the allegations of fraud that has been made to the entity? We look in terms of then the controls, in terms of then are there people that are skilled, for example, in that supply chain management division. Is the capacity of the supply chain management division there? And also we even do the walkthrough. You know, let's just do the walkthrough to find out if things are happening in the ground, like they are saying they are happening in their policies and procedures. So those are the things then that we're looking into. Then we will then, based on that process, I think I've mentioned the media, based on that process, then we will be able to identify those high risk transactions that we will have to look into them. And then the rest then of the population then will test it as part of the tender processes. So those are the things, that is then the process then that we follow. The documents then that we look into, for example, we look at tender files. We look at tender files, or if it's the quotation processes, we look at the quotations, the invoices. We basically reperform what management was doing. That's basically what we do. We reperform it, and in reperforming the work then that has been done by management in terms of their own policies and procedures, we then looking whether then they actually complied or not.
I guess maybe one of the benefits of reperforming the task is that you will see whether you arrive at the same outcome or result as them, and if the result you come to is vastly different from that of management, you may decide that maybe something needs to be looked into further. Is that right?
Absolutely, Chair. And the other important thing that I mentioned, when we're reperforming, we design procedures. We design our own procedures to say, based on that understanding of that process, to say, okay, the process is like this. So when we are testing tenders, then these are then the procedures then that is going to execute. And then the outcomes then of those procedures are the ones then that tells us whether management has followed their own processes or not, and also whether they have complied with the law or not.
And when you do that, namely reperforming the task that management are expected to have performed, is it easy to pick up if there's been a manipulation of the functions or of anything, or is that not necessarily easy? Take, for example, in terms of tender processes, if somebody has interfered with descriptions of goods to be supplied or services in order to favor a particular company, which one might end up bidding and so on. Is that something that's easy to do when you to pick up when you reperform, or that might be difficult?
Chair, it's not easy. It's very difficult, Chair, because us as auditors, we always talk about the inherent limitations of the audit process, because the audit process is persuasive than conclusive, because things that are done behind the scenes, because us as auditors were not there, things that were done then behind the scenes, and if management is very clever and ensure then that the documentation and everything is done properly, we may not be able to identify if there was any manipulation
Yes.
of things or not. So that is inherent
Yes.
in the process. Chair.
Yes, okay, thank you.
Thank you. Mr. Sokombela, I'd like to move on to the duties that apply to auditors, external auditors. You deal with that at page 8 of your affidavit. I see there that at paragraph 16, in fact, that Chair answers the question you had earlier, where it says the external audit of public entities is performed either by the AGSA or by a private audit firm. So
Yes, okay.
external includes both the private
Yes.
and the
Okay.
AG. Can you tell us, Mr. Sokombela, how the requirements differ for the AG and private firms, if they do at all?
Chair, there is no difference in terms of the requirements between the private audit firms and the public audit firms. However, I think I just want to qualify my statement in the sense that in the public sector or in government, there is more focus on compliance with legislation. However, in the private sector, the focus is whether the financial statements have been prepared in accordance with the financial reporting framework. So I think to answer the question, Chair, is that we all adhere to the same auditing standards. We all audit the same financial statements. For an example, in the case of South African Airways, how we are auditing South African Airways is not different to how the private sector firms ought to have audited South African Airways.
But would it not be true that what you refer to as public audit firms, government audit firms, the AG, they would be much more experienced. They would be much more experienced with checking compliance with legal prescripts that are applicable to public entities than would private firms, because private firms, insofar as maybe most of their clients are private companies, they might not be dealing a lot with pieces of legislation such as PFMA and whatever. So in terms of experience, would public audit firms not be more experienced in that?
Chair, the Auditor-General will be more experienced than the private sector firms as far as compliance, testing compliance is concerned.
But I guess nevertheless, any auditor from a private audit firm who accepts the job of auditing a public entity would be expected to familiarize himself or herself properly with what the AG's office would do in performing such a task, and make sure that the fact that they are a private firm should make no difference in terms of being able to pick up what the AG's office would have picked up.
Absolutely, Chair. And also, we work a lot with the private
Yes,
firms.
yes.
Because of the capacity issues as well, they do perform some of
Yes.
our audits.
Yes.
So I agree with you, Chair.
Yes. Do you think that I should approach the matter of private audit firms performing auditing for public entities on the basis that for all intents and purposes there should be no difference in how they audit public entities and how the AG audits those entities? I can judge them by the same standard.
Absolutely, Chairperson.
Okay, thank you.
Thank you. Mr. Sokombela, if you then turn over to page 9, and you deal here with instances where the AG opts not to perform an audit of a public entity. What broadly are the duties of private audit firms in that circumstance?
Chair, I think the most important thing is that when the private audit firms are auditing entities that the Auditor-General has opted not to audit, then the duties then and responsibilities of the private audit firms, there are responsibilities that are legislated and assigned, to the Public Audit Act. I think it's part 2 of Chapter 3 of the Public Audit Act. And the most important thing is that auditor that is doing the audit of the public entity, the most important thing is that they need to take note of the content of the Public Audit Act and must adhere to the requirements that are in, for example, the appointment of auditors in terms of Section 25 of the Public Audit Act. That appointment must be in accordance with that requirements, Chairperson, and also the discharge of the auditors also must comply with the process that is prescribed in Section 26 of the Public Audit Act. And the auditor must comply with the duties ascribed and may use the powers that are provided for in Section 27 of the Public Audit Act. The most important thing also is that the format and content of the auditor's report, Chair, must adhere to the requirements of Section 28, subparagraph 1 and subparagraph 2 of the Public Audit Act, read with the Auditor-General of South Africa's reporting guide. The reporting guide is attached to my affidavit as PS2. And the auditor's report template, we've got a auditor's report template as the Auditor-General that we use. The private audit firms are actually required to use that template. Chairperson is also attached in my affidavit as PS3. And also, we've got guidelines as well that the Auditor-General publish. And these guidelines are in our website, Chairperson. And also, we've got relationships with these firms as well, because we also gave them, if there's a guide that comes from our technical department, we submit that to them. And the auditor's report also that has been signed, also it should be submitted to the auditee. It should also be submitted to the minister, the relevant minister, if there is any minister, and also Auditor General and National Treasurer in accordance with Section 28, subparagraph 3 of the Public Audit Act.
And what broadly is the role of the Auditor General in the circumstances where the Auditor General opts not to do the audit? Does it play any role when a private audit firm carries out the audit of a public entity?
The role that we play as the Auditor General is for us to say we are there if you need us. We do offer to attend audit committees. We attend audit committees. when, for an example, there are certain technical things, for an example, especially when it comes to compliance issues, and also issues related to the audit of performance information, we offer ourselves to say we are available, because what we don't want is for the firms to feel that maybe they are alone, you know, in that. So that is basically then the role that we play. We don't want to step in their toes as auditors, because these are professionals. You know, they are qualified professionals and they are right. So we are very careful as the audit office then, in terms of then how then do we play that part.
When the AG's office opts out, does it then fall upon the SOE, for example, or government department, to get a private audit firm? Or is it the AG's office which says, because I'm opting out, I'm going to appoint a private auditing firm to then perform the function that I would otherwise have performed if I didn't opt out?
Chair, once the Auditor General opts out from auditing that specific state-owned entity, then the Auditor General then would not appoint. The auditor would leave then the appointment to the board and the shareholder. However, before that appointment is officiated, then in terms of the Public Audit Act, then a concurrence of the Auditor General is required.
Okay, thank you.
Thank you.
I'm sorry. So in a way, no private firm can go and audit a public entity without the Auditor General having said it's fine.
Absolutely, Chair.
Yes. And would the Auditor General's office, would there be circumstances where the Auditor General's office would say, we are not happy to concur? Maybe, for example, because they look at the firm and don't think that it has got the skills and capacity to do this function in a particular entity? Or do they always concur?
There are times, Chair, where the Auditor General may not concur, but in most instances, I think it's very few chances. Yes.
But, so most of the time, it will concur?
Absolutely, Chair.
Yes, okay, thank you.
Thank you, Chair. I do intend to deal with the process of that concurrence, and indeed with an occasion when that concurrence was not given in the context of the SAA audit. Mr. Sokombela, can I take you to the directive that you've attached to your affidavit? It's at page 141. This is the directive issued in terms of the Public Audit Act. Are you there? Sorry, your microphone's not on.
I'm there, Chair.
Thank you.
You can keep it on throughout, yeah.
Mr. Sokombela, I'd like you to turn to page 163 of that document.
I'm there, Chair.
Can you tell us what this is?
Chair, this is the monitoring checklist for audits not conducted by the Auditor General of South Africa.
And if we go through that checklist, it's what you describe as a monitoring checklist. It in the second table lists various requirements under the Public Audit Act. If you go over the page to 164, it lists further requirements under the Public Audit Act. And then there's a conclusion at the bottom where it is indicated whether further requirements are complied with or not. If you turn over to 165, at the bottom it then says evaluated by AGSA Business Executive Senior Manager. So you indicated earlier that the AG lets the audit firm get on with it. But it does seem there is an element of monitoring and oversight that takes place. Is that fair?
Yes, yes, Chair. Yes, Chair.
And just explain to me at what stage in the auditing process this gets completed and submitted?
Chair, this checklist gets submitted normally at the end of the audit process when the audit report has been signed, and it gets signed by the engagement partner that is responsible from the firm.
Who would be the engagement partner in the firm? Is it the chairperson or the most senior person or the person responsible for the auditing of the particular entity?
Chair, the engagement partner at a firm will be the person that is allocated to be the one that is responsible for that particular audit and will sign the audit report of that entity.
Thank you.
Thank you. Mr. Sokombela, can you explain what the impact is of there being non-compliance with the various requirements listed in the checklist? What does the AG do if it receives at the end of the audit a monitoring checklist which indicates that there hasn't been compliance?
Chair, I think Chair, in terms of then the question itself, for an example, if you look at the checklist, for an example, it's in most instances is looking at the requirements of the in terms of the Public Audit Act itself, of which in most instances, if for an example there were challenges during the audit process, those challenges ought to have been deliberated with the Auditor-General or the representative of the Auditor-General itself. So, if, for example, there is non-compliance with one of the requirements here, I think where I'm sitting, it's something then that needs to be escalated to the firm itself. For an example, if there's non-compliance with the requirements of the PAA and the general notice, or if there's the auditor's report to the accounting authority was not submitted within the time frame, depending on what the transgression is. Some of the transgressions, for example, may even be reported to the independent regulatory board for auditors to look into them.
Might it be a basis not to give concurrence the following year if that auditor is seeking concurrence for a further year of the same audit?
It may, Chair. It may.
I guess depending on the seriousness
Absolutely.
of the non-compliance.
Absolutely.
Okay.
Mr. Sokombela, if we can go back to your affidavit to page 12.
Before that, that checklist gets done after the auditing process has been completed, is that right?
Yes, Chair.
But you say that during the auditing process, or even at the beginning, if there is a situation that the firm knows is going to give rise to non-compliance, they should bring that to the attention of the AG at that stage.
Yes, Chair.
Is that right?
Yes, Chair.
But if, in other words, if the AG has not been told anything until they receive this checklist, from the AG's point of view, they would be entitled to expect that there is nothing that the firm was aware in advance would be problematic in the auditing process as far as they are concerned.
Yes, Chair.
Yes, okay. Thank you.
Thank you, Chair.
And I assume that once the AG's office has concurred in the appointment of a particular firm, the AG would designate one of the auditors in the AG's office to say, this is your baby. If some correspondence comes, you are the one to deal with it.
Absolutely, Chair.
Okay, thank you.
Mr. Sokombela, I now want to turn to the issue we've been alluding to, which is the process that's followed in order to determine whether to concur with or to reject the appointment of private auditors. Can you tell us what process the Auditor-General follows in order to do that?
Chair, if I may get the page number in the affidavit.
Sorry, we're at page 12 of the affidavit.
Page 12 of the affidavit.
And in fact, you deal with the process. You deal there with the legislation, and then you over the page on page 13, you deal with the process that's actually followed by the AG since the Public Audit Act came into effect.
Absolutely, Chair. Thank you, Chair. Chair, I think it's important that I mentioned that the Public Audit Act was promulgated in 2004. And when then the Public Audit Act before it became effective, the appointment of auditors were regulated in Section 58 to 62 of the Public Finance Management Act. But then when the Public Audit Act then became effective, those provisions in the PFMA became redundant, and then that particular schedule in the PFMA then was repealed, and then was replaced then by the requirements of the Public Audit Act, and that process now is regulated, Chair, by Section 25 of the Public Audit Act. And Chair, I don't know if you would want me to read it in verbatim for the purposes of the.
Maybe not necessarily. I think Mr. Mbikiwa also indicates not necessarily. Okay. But I just want to ask this. As a result of the repeal that you're talking about in the PFMA and the replacement, as I understand it, of the particular schedule, is the position that, therefore, if you go to the Public Audit Act and the PFMA, you will find that there are these provisions which are similar or even identical that deal with this particular issue, or they are only in the PFMA?
Chair, I think after Section 58 to 62 was repealed, so in the PFMA there is no there's no duty for the entities to appoint their own auditors.
Okay.
That has been conferred to the Auditor-General to deal with it.
Fine.
Indeed, Chair. The provisions simply don't exist.
Yeah.
They've
Okay,
been
no,
repealed.
that's fine. Thank you.
Mr. Sokombela, instead of reading the provisions of the Act, the Auditor-General, as I understand it, has a particular way of complying with the Act and a particular process that it follows.
Yes.
Can you talk us through what that process is?
Thank you, Chair. Chair, what the Audit Office does, the process that it follows, is that prior to the commencement of the financial year of the auditee, the Auditor-General will consider whether to perform the audit of that public entity or not. And then, Chair, in the event that the Auditor-General opts to perform the audit of the public entity that it has not audited during the previous year, what then the Auditor-General does, the Auditor-General notifies the auditee or the entity of its decision to perform that audit. The notification, Chair, to the auditee would be given prior to the commencement of the financial year of that auditee. The affected auditee must, prior to the commencement of the next audit and before the commencement of its financial year, select an external auditor after following a public procurement process in accordance with that auditee's supply chain management policy and procedures. The financial year end of the public entity is usually the 31st of March, and the appointment or reappointment of auditors occurs at the entity's annual general meeting. That is approximately June or July, but in some cases they can even go to September, October, depending on the scheduling of that. The selected auditor, Chair, must be an auditor in private practice that is registered with the Independent Regulatory Board for Auditors. Chair, once the auditee has selected a suitable external auditor in accordance with the public procurement process and its supply chain management processes, and prior to the appointment of such auditor by the responsible board or executive authority, the auditee must notify the Auditor-General in writing of the name of the selected auditor and provide all information required by the Auditor-General as provided for in the audit directive. The audit directive is attached as PS4. The Auditor-General must, within 14 days, Chair, of receiving the notification by the auditee, evaluate such notification and notify the auditee of its decision to concur with or reject the appointment the proposed process and of any appropriate conditions that the Auditor-General may have determined. If the Auditor-General has no objection to the appointment of the auditor selected by the auditee must proceed with the appointment of such auditor. Once appointed, the auditee must inform the auditor of such appointment as well as any conditions that the AGSA may have determined. Once the board or the minister responsible for the auditee has appointed the selected auditor, the auditee must notify the Auditor-General of such appointment and acknowledge acceptance of the conditions that may be set by the Auditor-General of South Africa. So, in essence, that is the process then that is followed, Chair.
Thank you. So the beginning of that process is where the Auditor-General notifies the entity if it opts to perform.
Yes.
If it doesn't notify it, it's deemed not to
Absolutely.
opt to perform
Absolutely.
it. You began your evidence by telling us some of the factors that would be considered in making that decision, such as skills and capacity.
Yes.
What are the factors that are considered in this decision as to whether to concur with or reject the appointment of private auditors?
Chair, the factors then that are considered is the independence considerations. And the Auditor-General then, what it does is to assess whether then the recommended audit firm is sufficiently independent to perform the audit of that public entity. And in this regard, then, the Auditor-General is guided by the relevant provisions of the Code of Ethics of Professional Accountants issued by the International Ethics Standards Board for Accountants, hereby referred to as ISPA.
Can I pause you there?
Yes.
Sorry. I just want to understand independence a little bit more.
Yes.
What do you mean when you talk about an audit firm being sufficiently independent?
Chair, I think the most important thing that we look into on the independence is independence to ensure then that there is no conflict of interest. There are no threats, that may impair the independence of that entity. One of the considerations, for an example, that we normally look at to say, does this firm perform non-assurance services to the public entity, for an example, consulting work? If maybe they are performing this consulting work, how big is that? Is it bigger than the audit fees that they're going to receive? Because if it's bigger than the audit fees, then there is a risk then that it might have an impact on their independence and their objectivity. And in the opening remarks, Chair, it was mentioned that also the independence should also be in appearance as well, because the perception then that if this audit firm is also have other interest, like your financial interest to the entity, then that might impair. There are other considerations in the independence, Chair. For an example, the issue of familiarity threat, because familiarity threat to independence as well, can be an issue. Where, for an example, maybe the firm might be, or the particular audit partner might be auditing that entity for many years, or there is a family member that is working in the public entity that might create also that conflict of interest. So when we're looking at independence, those are the considerations, Chairperson, that we look at. It's not all of them, but I'm just mentioning the few.
Yes.
Thank you. Can you continue telling us what the factors are?
I'm sorry. In order to establish whether these factors that you have mentioned are present, or whether those you might not have mentioned are present for purposes of the AG determining whether the firm has the requisite independence or an appearance of independence, does the AG's office put certain questions to the particular firm to answer so that it can know, for example, whether there is a relative or family member who works in in a particular entity, or how does it get the information that may be relevant to determining independence?
Chair, there are certain declarations that we request. Firstly, even from the entity that is appointing the external auditor, they need to declare to us, especially the issue of non-assurance services that are provided. So this is basically then how we source that information, to say, please make declaration to us whether then this information is like that or not.
And the non-assurance services, what would that be?
Chair, the non-assurance services will be maybe consulting work that maybe the firm is assisting the entity with, let's say, to ensure then that the assets of the entity are accounted for properly in the financial statements.
So, in other words, if the entity already has some relationship with the firm, then you want to look into the nature of that relationship.
Absolutely, Chair.
Okay.
Among you mentioned declarations that have to be made.
Yes.
Among these, are firms required to disclose joint business relationships with entities that are linked to the audit client?
Yes, Chair. Yes, Chair. Those declarations are required.
Thank you.
You said also that you look at whether the firm has been doing auditing for the particular entity for a long time. Do you have a cutoff point that guides you to say, look, a firm that has been doing auditing, has been auditing a particular entity maybe for 5 years, shouldn't continue beyond that? Is there some guideline as to how long is too long in terms of that relationship?
Yeah, Chair, I think for the tenure of the firm itself, there is not necessarily guidelines. However, for the engagement partner or the person that is going to be signing the report, I think normally we look at 5 years.
Okay.
Or if maybe it's more than 5 years, we would want to know the safeguards. What are the safeguards that are going to be put in place? Yes.
Okay. And the 5 years is not a guillotine. It's you look at it, but if there are certain measures in place, you might allow it to go beyond 5 years.
Absolutely, Chair.
Okay.
Thank you. Mr. Sokombela, if you could continue then telling us the factors that the AG considers in order to determine whether to give its concurrence.
I've mentioned the independence, Chair. And the second factor is compliance with public procurement prescripts. I think what I want to mention here is that on the compliance with the public procurement prescripts, we look at this at a high level, and we determine whether then the auditee has sourced the services of the private firm through its public procurement processes and has complied with its own supply chain management policy and procedures. And I think it's important that I mention that we look at this at a high level. It's not an auditor. It's not an audit, whether we say, give us all your documents, or can we audit whether you've done this thing properly or not. The other factor...
Sorry, I just want to pause after that factor as well. Does that mean that where an auditor is irregularly appointed, that'll be a basis on which the Auditor-General will decline to give its concurrence?
It may be a basis.
Okay.
It may be a basis, Chair. The other factor is the audit quality. And the Auditor-General then considers how the quality of the firm's work has been assessed. In this regard, the assessment is conducted by the Auditee's Audit and Risk Committee, as well as any firm and engagement inspections that are performed by the Independent Regulatory Board for Auditors. Those are also taken into consideration. In the case of a new appointment, because the Audit Committee might not know the firm, so we rely heavily then on the inspection report by the Independent Regulatory Board for Auditors. The other factor is adherence to formal and procedural requirements, where the Auditor-General verifies the auditee's adherence to the procedural requirements for the appointment of external auditors that are outlined in Section 25 of the Public Audit Act. And the Auditor-General also verifies that the firm is registered with the Independent Regulatory Board for Auditors.
Thank you. Now, you indicated that the Auditor-General must give its concurrence every year. How is it dealt with when an entity runs a procurement process but makes an appointment for auditors, say, for a 5-year period?
Chair, on our side as the Auditor-General, we don't prescribe in terms of how long that appointment should be. However, what is very important to us as the Auditor-General is to ensure then that they still, the public entity come back to the AG every year and request for concurrence. Because if you look at the Companies Act, the Companies Act, I think it's Section 90, if I'm not mistaken, of the Companies Act, that also regulates the appointment of auditors. And in most instances, that responsibility is allocated to the audit committee of the state-owned entity, because that is the governance committee that the external auditors works with in most instances. So there are instances whereby then an auditor then gets reappointed, And in terms of law, you can't say, I'm going to appoint you for 10 years. There are certain considerations that needs to be done. An audit is done, is completed, the audit report is signed. After then that is done, the audit committee is required then to assess that particular firm. They need to assess whether they still remain independent. They still need to assess whether they, they've performed the audit, in terms of then the quality standards. The audit committee may come and say, we're not satisfied with this auditor, so we need to discharge this auditor. And that is allowed in law. Hence, then the Auditor-General then will ensure then that they still come and show us that due process that has been followed for the reappointment of auditors.
So is it fair to say then that if an auditor is ever appointed by a public entity for more than a year, it's always subject to the risk that the Auditor-General might not concur with its continued appointment?
Absolutely, Chair.
So the first opting out on the part of the AG's office happens mostly, if not all the time, at the instance of the AG's office, but the subsequent acts of opting out in the years that follow might happen at the instance of the entity. Is that right? In other words, initially, the AG's office might not have been asked to opt out, because I guess nobody should ask them to opt out. But if they themselves, that is the AG's office, decides will opt out, they say we'll opt out this year. They don't say we are opting out for the next 5 years.
Absolutely.
Is that correct?
Absolutely, Chair.
And it may be that the following year they were going to opt out, but maybe before they make the decision, the entity requests them to concur to the firm continuing to audit. Is that right?
Yes, Chair, because the Auditor-General may say I'm opting out this year, but the Auditor-General may come next year, I'm saying I'm opting in.
Yes,
In actual fact, yes.
Yes,
yes.
okay.
Thank you. Mr. Sokombela, I'd now like to get into the process that was in fact followed for the years from 2011 to 2012.
I'm sorry, Mr. Mbigo, I'm interrupting you again.
No problem, Chair.
Does the AG's office at some stage become suspicious when a particular entity keeps on asking the AG's office to concur in the appointment of a private firm? If it's been happening for too often, does the AG's office become suspicious to say, why do these people want that firm to continue and they don't want us to come in for so many years? Why are they not leaving it to us to decide if we are opting out each year?
Chair, not necessarily, because once the Auditor-General opts out, we leave then the decision to the entity itself. It is when then the Auditor-General has decided to opt in, then where then there's pushback, then that maybe the Auditor-General might be suspicious of maybe why.
Or would there ever be a pushback when the AG wants to continue with his job?
Not that I remember, Chair.
Not really, but if it happened, it would be suspicious.
Absolutely, Chair.
Yes. No, I just find it strange. I would imagine that because the auditing of every public entity is primarily the job of the Auditor-General, and it's up to the Auditor-General to opt out in a particular year. I would imagine that an entity which has received an opting out notice from the AG this year, and the AG has concurred in the appointment of a private firm to do the job, I would have imagined that that firm should have no problem if the following year the AG says, I'm coming back, or I continue with opting out, and therefore I would expect that they would be neutral.
Absolutely.
Rather than them seeking a situation where the AG is kept out. You understand my...
I do, Chair.
Yes.
I do, Chair. Yes.
Okay,
Yes.
all right, thank you.
Thank you. Mr. Sokombela, can we turn to the concurrence that the AG gave in the course of the SAA audit? We picked that up on page 18 of your affidavit. Can you explain to us who was appointed to the SAA audit and what view the AG took of that appointment in 2011-2012?
Chair, I just want to mention that in 2011-12 financial year, I was not personally involved in the appointment of the external auditors for SAA. I only became involved in the 2015-16 financial year. However, I've been briefed by my colleagues that were personally involved with this, that during the 11-12 financial year, the Auditor-General opted not to perform the audit of South African Airways. And on 5 September 2011, South African Airways consulted the Auditor-General to appoint PricewaterhouseCoopers as well as Nkonki Inc. as joint auditors for a period of 5 years. However, I just want to, in my affidavit, I said for a period of 5 years. I just want to clarify that, Chair, because the appointment that was made was for 2011-12 financial year.
One financial year.
It was for one financial year. It
Yeah.
was not for a period of 5 years. However, they ended up staying for 5 years. Yeah, so
Oh,
so
okay.
I think I just want to clarify that in the
Yes.
affidavit.
But what is important is whether whether the request from the SAA that the AG concurs in the appointment of PwC and Nkonki, whether that request asked that the AG should let them go on for 5 years, even though the AG said 1 year this year, then allowed it the following year, 1 year at a time. But was the request that the AG should allow them for 5 years? Do you know that or do you not know?
Chair, the request was for 1 year.
For 1 year.
It was for 2011-12 financial year.
Oh, okay,
Yes.
okay. It may be, Mr. Mbikiwe, that there should be a short supplementary affidavit that just clarifies
Corrects
this
that.
part. Yeah, okay.
Thank you, Chair.
Thank you, Chair. Chair, then when that request then was made, the Auditor General concurred in writing for 1 year appointment and notified the chairperson of the board of SAA on 12 September 2011. There were no issues of concerns that were identified, and a copy of the concurrence letter that was sent is attached as Annexure PS 11 to this affidavit. Chair, on the 23rd of July 2012, South African Airways consulted the Auditor General on the reappointment of PricewaterhouseCoopers and Nkonki, again as joint auditors for the 2012-13 financial year. And
Maybe-
also,
I'm sorry, just to cover this in a particular way. You did say that you were not involved in 2011-2012.
Yes.
You only got involved in 2016 or 2015?
2015-16, Chair.
Yes, yeah. But what you are dealing with here, are you dealing with matters that appear from records that are available to you at the Auditor General's office?
Chair, I'm dealing with matters that are available to me at the Auditor General's office, and the
Yes.
conversations or deliberations that I had with my colleagues that
Okay.
were responsible at the
Okay,
time.
all right. Thank you.
Chair, maybe for the purposes of this hearing, maybe I must say from 2011-12, 2012-13 financial year, 2013-14 financial year, and 2014-15 financial year, South African Airways requested the concurrence of the Auditor General, and
Each year.
each year, and there were no issues that were identified by the Auditor General, and the concurrence was given. I just want to summarize instead of
Yes.
going through each
no,
and
that's
every
fine. No,
each and every
that's
year.
fine.
Yes.
That's in order. That's in order. And the documentation reflecting that request and the granting of that request, the concurrence is all attached here.
Is all attached, Chairperson.
Okay,
Yes,
thank you.
is all attached.
Yeah.
Thank you. Mr. Sokombela, in those years that the AG was giving its concurrence, was it disclosed to it that the appointment had only been for 1 year.
Absolutely, Chair.
So SAA told the AG that in 2011, 2012, it had run a tender process that was only for a 1-year appointment.
Absolutely, Chair.
So why in 2012, 2013, and 2014 did the AG give its concurrence?
Chair, you know I must say the Public Audit Act itself, I think, was a new legislation, 2004. And the issue of the issue of concurrence has grown or has matured in the organization. The Gazette or the directive that Mr. Bikiwa referred me to is one of the latest gazettes that we have. However, the gazette that was applicable at the time, I think it's attached here, at the time, did not have that requirement for us to actually look at the public procurement process. Whether the public procurement process is done, we would rely heavily on the assessment that has been done by the audit committee, by the board, and also by the minister. And then we will rely then on those determinations then that they've made. However, as the time goes by and as our processes also are maturing, then we did then started to consider whether then there was procurement process or not. So, in hindsight, where I'm sitting here to say maybe in those years, should we have considered whether maybe the public procurement process was followed or not? Definitely yes. Maybe we should have considered that. However, we're a growing organization. You know, as we grow, we do then deal with certain issues.
Is my understanding correct that you are saying during those years it was not a legal obligation on the Auditor-General to check whether, before concurring, the firm that is proposed to do the work has been appointed in compliance with the PFMA, for example? Or are you saying it was an obligation, but we had a certain understanding which has since changed? We now look at it, but at that time we didn't look at it because we didn't understand that to be our obligation, or we understood it to be our obligation, but we were quite happy in being guided in regard to that by what the Risk and Audit Committee says. Which of these two is the right one? Or three, I think.
Yes, it's three, Chair. Chair, in terms of the law, it is a requirement to go through the procurement process. However, I think what I want to emphasize is that the appointment of auditors is quite tricky in the sense that, for an example, in 2011-12, there was procurement that was done, meaning that how the auditors were brought to SAA, there was a process that was done. But then, where then the trick comes in, Chairperson, is when then you're dealing with reappointment, because the auditors are already here.
Or extensions.
Yes,
Yeah.
yes, or the extensions, because the auditors are already here, and there's then the Companies Act requirements, then that the entity then follows, which is a due process. It's not necessary to say there's no due process. It's a due process that they follow. And we, at the time then, we looked at that, we only relied on that particular instance. And also in practice as well, it's not practicable to have an auditor only for 1 year. Only because in most instances, an auditor for 1 year is just to understand how your business is. And subsequent then to that year, that's when then the auditor starts to add value to the particular entity.
So is your answer therefore that even during those years, the AG's office was under a legal obligation to check whether there had been compliance with PFMA, for example, in the appointment of the particular firm? In regard to SAA in 2011, a process had been followed before the first appointment, where as we as the Auditor-General's office now in 2020, we regard it as our duty that even when there are requests for extensions or reappointments, that we should check that the PFMA is complied with. But at that time, we did not understand this to be an obligation on us. Is that what you are saying?
Chairperson, that is what I'm saying, to say we did not understand it to be
Yes.
our obligation
Yes.
at that particular point in time.
Yes.
And also, I think one other important aspect as well is on our side to say the reappointment of auditors in the Companies Act is governed by the Companies Act in terms of then how the reappointment of external auditors needs to be done. And at the time, we understood that to be an enough process, as long as they stick to what they did in 2011-12 financial year. Yes.
Okay. But your understanding now is that apart from the process in the Companies Act, there must also be compliance with the process in terms of the PFMA, even with reappointments and extensions.
Chair, it is our understanding. However, what also we don't want to do as an audit office is to make it difficult for the state-owned entities to appoint auditors. Because I think the law itself is quite tricky in the sense that it says the appointment should be for a period of 1 year. However, myself as an auditor, I know that it's not practical to have an auditor only for 1 year. So there may be then due processes then that needs to be followed. For an example, Chair, some of the entities, what they normally have is to have a policy on how they need to appoint auditors, which is a policy that is not necessarily the supply chain management policy, but to say we're going to have a policy, for an example, to say we're going to appoint auditors, let's say for a period of 5 years. However, when we're signing a contract with them, we're going to have provisos that says that you're only going to be valid for a year, and then we will reconsider each year in terms of then what happens. So that is basically then that is the trick. I think that is the trick, if I may put it, in this particular. It's not like the procurement of any other goods or services. It's a statutory, procurement. It's a procurement of a statutory auditor.
Well, it's important that I know what the position is, and it's important for me to know what the AG's understanding of what the position is, because the AG deals with these things all the time.
Absolutely.
And I need to know if there are challenges that are posed by the law as it currently stands, because it may be that some recommendations need to be made to say the law as it currently stands, it either creates confusion or is difficult to implement, because as auditors we know that an auditor who goes in for 1 year, really that year is used for the auditor to get to know the business. So it's impractical and unrealistic to say there should be appointments for 1 year, because we know almost invariably it's more than 1 year. So maybe it should be more than that. So So I just want you to know that I'm interested in understanding that. But as I understand it, at a certain time, it was an obligation, but the AG's office understood it in a certain way,
Yes.
and therefore acted on the basis of that understanding. Right now, it understands it differently, and it acts in accordance with the new understanding.
Absolutely, Chair.
Okay.
Chair, just on the issue of the concern you've raised, this will be dealt with in more detail in the evidence tomorrow.
Okay.
But certainly, other state-owned entities have found a way to deal with this issue.
Okay.
And if I
Okay.
can just refer to an ESCOM RFB, as I say, this will be referred to in the evidence tomorrow.
Yes.
But the condition of the tender says the appointment will be made for a period of 5 years relating to the audit of 5 financial years from the 2014-15 financial year onwards, subject to the following conditions. And then one of the conditions is annual consultation with the Auditor-General before the appointment for a specific year is finalized.
Okay. Okay. Yeah. Thank
So
you.
there's a sort of practical
Yes. Way.
illustration. Yeah.
Okay. Okay.
Can I ask one follow-up question, Mr. Sokombela? In those years after 2011, 2012, so in the years after the procurement process had been run, but to which the procurement process itself didn't apply, is it fair to say that it was for now I'm saying SSA, apologies, Chair. Was it for SAA to indicate to you what procurement process had been followed? Was it for SAA to disclose that to you?
Absolutely, Chair.
And did it do so?
In 2011-12, I've been made aware that they did so. Subsequent to 2011-12, what then they gave us is then the resolutions from their own governance structures that they have considered the competency of the auditor, the quality control issues. They are happy in terms of the conduct of the auditors, and they would want to reappoint them.
But-
So they didn't submit the procurement issues.
Okay.
Yeah.
Thank you.
Of course, it will be important to understand whether, from SAA's point of view, there might have been any confusion about whether for the subsequent years they should do that. It may be that there was no confusion. They knew they needed to do that. But it may be that they didn't know whether for the extensions they needed that as well.
Chair, we'll address it tomorrow, but the documents reveal that there was no confusion.
Okay. Thank you.
Mr. Sokombela, can you then actually, Chair, I'm going to move into the 2015-16 financial year,
That's
which is a more detailed issue, and I see
fine.
that we're at 5-1.
Yes. Do you suggest we use the 5 minutes before 1 o'clock, or are you suggesting that it might be convenient to?
I'm suggesting it might be convenient to adjourn now, Chair, just
Yes.
because I'll begin but won't really get into the
Yes.
following
Okay.
issue.
No, that's fine. We will take the lunch adjournment and we will resume at 2 o'clock. We adjourn.